Judge, I object to this witness testifying. The defense has never provided us information telling us that they were calling in this medical expert. What happens next? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney, and let me share with you what happens in this instance. Let's say this is a medical malpractice case, and now the defense is calling their medical expert to testify. And the defense lawyer says, "Your Honor, I called Dr. Jones to the witness stand." And I jump up, I say, "Objection, Judge. He didn't tell us he was calling in a medical expert. He never provided us notice about who they're calling in or what the expert was going to be talking about. I object to this witness testifying." Now the judge turns to the defense lawyer and says, "What do you have to say about that, counselor?" And now he's going to make some excuse. "Judge, we only got this witness's information last night. I didn't retain him until last night. And I was going to provide Mr. Oginski all this information, but I didn't have his contact information." Or some other excuse. So now the judge has to make a decision. You see, in medical malpractice cases, each side has an obligation to give the other side information about what experts we have retained, where they went to medical school, whether they are board certified, where are they licensed, what state, and now, what are they going to be talking about? Now, we know what they're basically going to say. Our expert, the plaintiff's expert, is going to say the doctor did everything wrong. The defense medical expert is going to turn around and say the doctor did nothing wrong. Okay, we know that, but we need more detailed information. So now the judge has a number of options available. The judge can turn around and say, "This witness is not testifying. We are precluding him from testifying. And now call your next witness," which could be a real problem for the defense. Or the judge can say, "Go ahead, put him on the witness stand. You can question him. And Mr. Oginski, if you need time, I'll give you a couple of hours or we'll have him come back the next day." Now that's not the ideal situation for me because it doesn't give me enough time to do my research on this doctor in order to dig up some dirt that I can effectively cross-examine him. The alternative is I go ahead and cross-examine him immediately after the defense lawyer finishes questioning. Now, I can try and do that on the fly, but it's not an ideal situation. Another alternative is for the judge to go ahead and sanction and fine the defense lawyer for not following the court rules. So why do I share this quick information with you? I share it with you just to give you an insight and an understanding into what goes on in these medical malpractice cases here in New York. You know, I understand and realize you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, but you haven't done so yet because you still have questions, what I invite you to do is pick up the phone and call me. I can answer your questions. You know, this is something I do every single day and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.